Shut your mouth, boy. Since when does a black kid from the gutter get to speak in my court?
Judge Gerald Thornton didn't even look up when he said it. He just waved his hand, like swatting away a fly, and nodded to his bailiff. Darnell Scott, 17 years old, standing in a borrowed suit.
Your Honor, I have the right to... You have no rights here. Deputy, cuff him!
The bailiff grabbed Darnell's wrists. The handcuffs clicked shut. 40 people watched. Nobody moved. But here's what the judge missed. The manila folder pressed against Darnell's chest held enough evidence to destroy everything he had built in 30 years. And by tomorrow morning, the whole country would know it. Cedarville sat in the deep belly of the American South. The kind of town where everybody knew everybody, but not everybody was treated the same. A single set of railroad tracks cut the town clean in half. To the west, neat lawns, good schools, and streets that got repaved every spring. To the east, cracked sidewalks, boarded-up storefronts, and a neighborhood the city council pretended didn't exist. Darnell Scott grew up on the east side. He lived with his grandmother, Lorraine Scott, in a small house with peeling paint on the outside and not a speck of dust on the inside. Lorraine kept that house spotless, the way she kept her dignity, fiercely, quietly, and without asking anyone's permission. She worked 2 jobs, morning shift at the hospital laundry, night shift stocking shelves at the grocery store across town. Most days, Darnell only saw her for 20 minutes between shifts, standing at the kitchen counter, eating cornbread and drinking black coffee before heading back out the door. But those 20 minutes mattered. "Baby, this world will try to make you small," she told him once, buttoning up her work coat with tired fingers. "Don't you let it. You just be ready when your moment comes." Darnell never forgot that. At school, Darnell was the quiet one. Not because he had nothing to say, but because he learned early what happened when a black boy in Cedarville spoke too loud, too fast, or too smart. Teachers called it attitude. The principal called it defiance. So Darnell learned to keep his mouth shut and his eyes open. But every evening, after homework was done and the house went still, Darnell walked 6 blocks to the Cedarville Public Library. He sat at the same scratched wooden table under the same flickering lamp, and he read. Not novels, not comics. Law books, court transcripts, constitutional amendments, judicial ethics codes. He filled notebook after notebook with case citations written in small, precise handwriting. The kind of handwriting that comes from someone who knows every word matters. Nobody knew about the notebooks. Not his teachers, not his friends, not even Lorraine. That was Darnell's world. Small, quiet, invisible. Now let me tell you about the man who ran the other side of town. Judge Gerald Thornton had sat on the Cedarville County bench for 30 years. 30 years of gavels and sentences and absolute, unquestioned power. The white establishment loved him. The Chamber of Commerce gave him awards. The local paper ran a profile on him every few years with the same headline, Guardian of Justice. And the same photograph of him standing in front of the courthouse with an American flag pin on his lapel and a smile that never quite reached his eyes. But on the east side of those railroad tracks, people didn't call him Guardian of Justice. They called him the Hammer. Because when a black defendant walked into Gerald Thornton's courtroom, the outcome was already decided before the first word was spoken. Thornton never raised his voice. He didn't need to. He had something worse than anger. He had contempt. The quiet, settled kind. The kind that sits behind polished manners and pressed robes and makes a man believe, truly believe, that the people standing before him are less than human. "These people don't respect the law," Thornton once said to a colleague over lunch at the country club, cutting into a steak without looking up. "They only understand consequences." These people. That's how he said it. Like he was talking about a different species. And for 30 years, nobody challenged him. Not the prosecutors who watched him hand down maximum sentences to black teenagers for first offenses. Not the public defenders who advised their clients to plead guilty because fighting Thornton was a war nobody could win. Not the local politicians who needed his endorsement every election cycle. Nobody. Until a 17-year-old boy from the east side of the tracks decided he'd had enough. It started on a Tuesday afternoon in the Cedarville High School parking lot. The kind of ordinary afternoon that changes everything. Darnell's best friend, Calvin Moore, got into an argument with a white student over a parking spot. Words were exchanged, voices got loud. Nothing more. No fists, no threats. Just two teenagers running hot over something stupid. Then the school resource officer showed up. He walked right past the white student, didn't even glance at him. He went straight for Calvin, grabbed him by the arm, pushed him against the car. Then he turned to Darnell, who was standing 5 feet away, holding his backpack, doing absolutely nothing. "You two, hands where I can see them." Darnell didn't run, didn't resist. He just asked a question. The most dangerous thing a black boy in Cedarville could do. "Sir, I just want to understand the basis for detaining us when the other student was also—" "That's enough. Hands behind your back." The white student walked to his car, drove away, went home to dinner. Darnell and Calvin were put in the back of a patrol car. The charge? Disorderly conduct. And for Darnell, because he dared to ask a question. Resisting a peace officer. He was 17 years old. He had never been in trouble, not once. And now he had a case file with his name on it, heading straight for Judge Gerald Thornton's courtroom. The gears were already turning, and Darnell didn't know it yet, but he was about to walk into the fight of his life. The juvenile processing center smelled like bleach and bad decisions. Darnell stood under a strip of fluorescent light that buzzed like a dying insect, while a clerk with bored eyes rolled ink across his fingertips, one by one, pressing them onto a card like he'd done it 1,000 times before. Because he had. Fingerprinted, photographed, filed. Darnell looked down at his hands afterward. The ink sat in the creases of his skin, dark and stubborn. He went to the bathroom and scrubbed them under cold water until his knuckles ached. The ink didn't come off. Not all of it. It stayed in the lines of his fingers like a stain the system had already decided he deserved. Lorraine arrived 40 minutes later. She'd left her night shift early, walked off the floor without a word when the call came, and now she stood at the front desk in her work uniform, signing papers with a hand that wouldn't stop trembling. She used the grocery money to pay the processing fee. $42. That was half of what she'd budgeted for the week. She didn't say anything until they were in the car. The engine idled in the parking lot for a long time before she spoke. "You didn't do anything wrong, Darnell." Her voice cracked on his name. "But that don't matter to them. It never has." Darnell stared at the ink on his fingers and said nothing. That night, he sat on his bed and pulled out the letter he'd been carrying in his backpack for 2 weeks. The pre-law summer program at the state university, the one he'd spent months applying to, had sent a conditional acceptance. Full scholarship, housing included. The first real door that had ever opened for him. But there was a line on the application he hadn't noticed before. Page 4, Section 6. A single question printed in small black type. Have you ever been arrested or charged with a criminal offense? He read it 3 times, then he folded the letter and put it back in his bag. He turned off the lamp. He lay in the dark and listened to the freight train roll through town, that low, heavy rumble that shook the walls every night, and he wondered if the door had already closed. 3 days later, Darnell sat in the waiting room of the Cedarville County Public Defender's Office. The walls were gray, the chairs were plastic. A water cooler in the corner made a gurgling sound every few minutes like it was choking. Stacks of case files covered every surface, Desks, chairs, windowsills, like paper snowdrifts. Attorney Vivian Cole walked in 11 minutes late, holding a coffee in one hand and 3 folders in the other. She was in her early 40s, black, sharp-eyed, and running on what looked like 4 hours of sleep. She sat down across from Darnell, opened his file, scanned it for maybe 3 minutes, and closed it. Okay, Darnell, here's where we are. You've been charged with disorderly conduct and resisting a peace officer. Given your clean record, I can probably get this knocked down to a lesser charge. You plead guilty, do some community service, and we move on. Plead guilty, Darnell repeated. Not a question, a taste test, like he was chewing on something bitter. I know it's not fair, Vivian said. She leaned back in her chair and rubbed her eyes. But I'm going to be honest with you. Your case is assigned to Judge Thornton, and fighting a charge in front of Thornton, especially for a young black man, that's a war you can't win. He will make an example of you. Darnell looked at her for a long moment. Then he said something that made her stop rubbing her eyes. What if he's the one who should be made an example of? Vivian stared at him. She opened her mouth, closed it, opened it again. Darnell, I admire the courage, I do. But you don't know what you're up against. I know exactly what I'm up against, he said quietly. I've been watching. Vivian didn't know what that meant yet. But she would. 1 week later, Darnell was back in the courthouse, not for his own hearing, but early, sitting in the gallery, watching. Thornton's docket was full that morning, case after case, most of them black defendants, most of them poor. Most of them pleading guilty because their public defenders told them the same thing Vivian had told Darnell. Fighting Thornton isn't worth it. But there was one case Darnell couldn't look away from. A young black woman, maybe 23, 24, stood before the bench with her hands clasped in front of her. She was thin. She wore a clean blouse that she'd probably ironed that morning. She'd been charged with shoplifting. First offense. The items she stole were diapers and baby formula. Her public defender asked for leniency, community service, a suspended sentence. He pointed out that she had no prior record, that she was a single mother, that she was employed part-time and trying to get back on her feet. Thornton listened with his chin resting on his hand. When the defense finished, he straightened up, adjusted his glasses, and delivered his ruling like he was reading a grocery list. 60 days in county jail. The woman's knees buckled. A sound came out of her. Not a scream, not a word. Just a raw, broken noise that filled the courtroom like smoke. The bailiff stepped forward. The judge didn't flinch, didn't blink. Personal circumstances, Thornton said, his voice flat and final, do not excuse criminal behavior. Darnell sat in the back row and watched. His jaw was tight. His hands were still. But under his seat, resting on his knees, his notebook was open, and he was writing. He'd been writing for 18 months. Names, dates, charges, sentences, race. Every case that passed through Thornton's courtroom that Darnell could find in the public record. Every pattern, every gap, every number that told a story the judge didn't want anyone to read. Nobody noticed the quiet boy in the back row with the notebook. Nobody ever did. Then came the day Darnell had been waiting for. His preliminary hearing. He stood before Judge Thornton in the same courtroom where he'd watched the young mother get sentenced for stealing diapers. He wore the same borrowed suit. He stood straight. He spoke clearly. Your Honor, I respectfully request the opportunity to address the court regarding the factual basis for you don't speak unless spoken to in my courtroom. Sir, under procedural code, I have the right to. Thornton's gavel hit the bench so hard the microphone popped. Deputy Harmon, cuff this boy. Contempt of court. The courtroom went cold. Ray Harmon walked toward Darnell with the handcuffs already open. Darnell didn't run, didn't flinch. He stood still and let the metal close around his wrists. The click loud enough to echo off the marble walls. In the second row, Lorraine Scott stood up. Her hand was over her mouth. Her eyes were wide and wet. She looked at her grandson in handcuffs, and her whole body trembled, not with weakness, but with a fury she had spent 60 years learning to contain. Thornton looked down at Darnell one last time. "Maybe a night in holding will teach you some manners." Then he moved on to the next case, like nothing had happened. Like the boy in handcuffs was already forgotten. But Darnell Scott was not the kind of boy who got forgotten. He was the kind who remembered everything. The juvenile holding cell was 6 feet by 8 feet, gray walls, metal toilet, thin mattress. The fluorescent light above didn't flicker, it just hummed, steady and relentless, crawling into Darnell's skull. For the first time, he looked scared. Not the kind you show, the kind you carry in your chest, like a fist pressing against your ribs. He was 17. He was alone, and the system that was supposed to protect him had just locked him in a cage for using his voice. He reached into his sock and pulled out a folded photocopy, a judicial ethics statute he'd found at the library 3 weeks earlier. Grounds for removal of a sitting judge, abuse of authority, pattern of discriminatory conduct. He read it 3 times. He thought about the young mother who got 60 days for diapers, about Calvin, about every name in his notebook. If he took the plea deal, it would follow him. The scholarship would disappear, and Thornton would do it again tomorrow, and the day after, and the day after that. But if someone had the proof, if someone had been counting, then someone could stop it. Darnell had been counting for 18 months. He folded the paper, put it back in his sock, and made the decision that would change everything. He wasn't going to fight his case. He was going to take down the judge. The next morning, Lorraine was waiting outside the detention center at 6 a.m. She pulled him into her arms without a word. In the driveway, she turned off the engine and looked at him. "Tell me what you need." "I need you to trust me, Grandma." "Baby, I've been trusting you since the day you were born." Darnell went inside, showered, and walked straight to the public defender's office. He found Vivian at her desk and dropped his notebook in front of her. It landed with a thud that made her coffee ripple. She opened it, and for the next 5 minutes, she didn't speak. 18 months of data. Every case from Thornton's courtroom pulled from public records at the library. Defendant name, charge, race, sentence, all organized in neat columns. Black defendants averaged 45 days for first offense misdemeanors. White defendants, probation or community service. Black juveniles received maximum sentences 84% of the time. White juveniles had charges dismissed in more than half their cases. Vivian turned the pages slowly. She looked up at Darnell. Really looked at him. "Darnell, where did you learn to do this?" "The library's free." She closed the notebook, pushed her case files aside, all of them, and pulled her chair forward. "Tell me everything." Over the next 2 weeks, they turned her office into a war room. They pulled sentencing records, cross-referenced by race and outcome. The pattern wasn't subtle. It was a canyon. Then they found the case that cracked it open. 3 months before Darnell's arrest, a white teenager at Cedarville High, same school, same grade, was charged with the exact same offense, same statute, same circumstances. Thornton dismissed the charges. No fine, no record. Side by side, identical charges. One walked free, the other was handcuffed in court. But Darnell wasn't finished. He'd found that Thornton's re-election campaigns received significant contributions from Ridgeline Corrections, the private company operating the county's juvenile detention facility. More kids in detention meant more profit. "He's not just biased," Darnell said, laying the financial records next to the sentencing data. He's getting paid. Vivian stared at the documents. Darnell, if we bring this forward while your case is pending, he will bury you. He's already been burying people. I'm just the first one who dug up the proof. Vivian leaned back. She thought about her 93 open cases, her exhaustion, what this would cost her. Then she thought about the mother who got 60 days for diapers. She picked up her phone. I know a journalist. Her name is Claire Whitfield. She's been looking into Thornton for months. I think it's time we talked. That night, Lorraine stood in the kitchen doorway, watching Darnell organize papers on the table. She didn't ask what they were. She just looked at him. This boy she'd raised from nothing, with nothing, and said the truest thing she'd ever spoken. I raised you for a moment like this. I just didn't think it had come so soon. The diner sat on the edge of town, past the last stoplight, where Cedarville started turning into empty fields and gravel roads. The kind of place with sticky menus, burnt coffee, and booths where the vinyl seats had cracked down the middle and been patched with duct tape. Nobody came here for the food. People came here to not be seen. Claire Whitfield was already sitting in the back booth when Darnell and Vivian walked in. She was mid-30s, white, with sharp eyes and ink-stained fingers. A digital recorder sat on the table next to a half-eaten piece of pie. Her laptop was open but turned away from the door. A habit, not a choice. Claire had been an investigative journalist for 11 years. She'd covered corruption in small towns across the South, crooked sheriffs, rigged contracts, embezzlement schemes that ran through city councils like rot through wood. 6 months ago, she'd started looking into Thornton, not because anyone asked her to, because the numbers caught her eye the same way they'd caught Darnell's. But Claire had something Darnell didn't. She had audio. 6 months ago, a woman named Patricia Bowman walked into my office, Claire said, keeping her voice low even though the diner was nearly empty. She was a court clerk in Thornton's office for 9 years, quit last spring, walked out one day and never went back. Vivian leaned forward. Why did she quit? Because she couldn't stomach it anymore. Claire turned her laptop around. On the screen was an audio file, a waveform frozen in place, waiting to be played. Patricia recorded him, multiple times, in his chambers behind closed doors, when he thought nobody was listening. Claire pressed play. The voice that came through the laptop speaker was unmistakable. Gerald Thornton. Calm, casual, the way a man sounds when he's among people he trusts, when the robe is off and the gavel is down and there's no gallery watching. He was talking about black defendants, not with anger, worse, with amusement, laughing about teaching them their place, calling them animals, saying things that would make the evening news anchors choke on their teleprompters. Vivian's jaw tightened. Darnell sat perfectly still. There's more, Claire said. She clicked to a second file, different date, more recent. This one was about Darnell. Thornton's voice filled the booth, casual, almost bored, talking to someone in his chambers about the upcoming hearing, about a black teenager who'd had the nerve to question a police officer. And then the line that changed everything. That boy needs to learn what happens when one of them talks back in my court. I'll make sure of it. Claire paused the recording. The silence in the diner was thick enough to touch. Do you understand what that is? Vivian asked, almost whispering. Darnell understood. He didn't need a law degree to know. What they'd just heard was predetermination. A judge deciding the outcome of a case before the hearing even began, motivated by racial bias. It wasn't just misconduct. It was grounds for immediate removal. I've been waiting 6 months to use these, Claire said, closing the laptop. But I needed more than audio. I needed the data to back it up. The pattern, the proof that this wasn't a one-time slip. I needed someone who could stand in front of a board and show them the whole picture. She looked at Darnell. And then your story showed up in a police report. and I realized someone had already done the work I couldn't. Darnell didn't speak for a moment. He looked down at the manila folder sitting on the table between them, the same folder he'd been carrying since the first hearing. He opened it. Inside, the notebook data, the side-by-side case comparison, the campaign finance records linking Thornton to Ridgeline corrections, and now, Claire's recordings, statistical evidence, financial conflicts of interest, comparative case analysis, and the judge's own voice, on tape, admitting what everyone on the east side of the tracks had known for 30 years. Darnell closed the folder. He pressed his hand flat on the cover. "He thought I had nothing," Darnell said quietly. "That's why he never saw me coming." Vivian looked at the folder. Then she looked at Darnell. Then she looked at Claire. "How do you want to play this?" Claire asked. Vivian pulled out a yellow legal pad and uncapped her pen. "We file the judicial misconduct complaint with the State Conduct Board. We attach everything, the data, the finances, the recordings, all of it, and we time it with your article." "And Darnell's case?" Claire asked. "It's still pending in Thornton's court." "That's the point," Darnell said. Both women turned to look at him. "If we wait until my case is resolved, he controls the outcome. He buries me first, and then nobody listens. We have to move while I'm still standing in front of him, while the whole courtroom is watching." Vivian studied him for a long moment. 17 years old, borrowed suit, dollar store notebook, and a legal strategy that half the attorneys in the state wouldn't have the nerve to execute. "Okay," she said. "Then we go." Darnell picked up the manila folder and held it against his chest, the same way he'd held it that first day in court, when Thornton told him to sit down and shut his mouth. Same folder, same boy, but everything inside, and everything ahead, had changed. The morning of Darnell's trial, the sky over Cedarville was the color of dirty dishwater. Low clouds, no wind. The kind of weather that feels like it's holding its breath. Darnell stood on the courthouse steps at 8:15, wearing the same borrowed suit. Lorraine had pressed it the night before, twice, and sewn the button back on the left cuff that had been loose since the first hearing. She stood next to him now, her purse held tight against her hip, her chin high, her eyes scanning the courthouse door like she was walking into enemy territory. Because she was. Vivian met them in the hallway outside courtroom B. She carried a leather briefcase, not the usual armload of loose folders. Today, everything was organized, tabbed, color-coded. She'd been up since 4 a.m. "How are you feeling?" she asked Darnell. "Ready," he said, and he meant it. The courtroom was full. Not packed, not yet, but fuller than usual for a juvenile disorderly conduct case. Word had gotten around, not about the complaint, that was still sealed, but about the boy who'd been handcuffed for speaking. In a town like Cedarville, that kind of story travels fast. People from the east side filled the back rows. A few teachers from the high school sat near the middle. Calvin Moore sat in the third row with his mother, his knee bouncing. Judge Gerald Thornton entered at exactly 9 o'clock. Black robe, American flag pin, the same unhurried walk he'd perfected over 3 decades, the walk of a man who owned the room before he entered it. "All rise," Deputy Harmon called out. Everyone stood. Thornton settled into his chair, adjusted his glasses, and opened the case file without looking at the gallery. Case number 2024-JV-0331. The State versus Darnell A. Scott. Charges: disorderly conduct, resisting a peace officer, and criminal contempt of court. He looked up. His eyes found Darnell the way a hawk finds a mouse in an open field. "Is the defense ready?" Vivian stood. "Yes, Your Honor. And before we proceed, the defense has a preliminary motion to present." Thornton raised an eyebrow. Preliminary motions in juvenile cases in his courtroom were rare. Preliminary motions from overworked public defenders were almost unheard of. Go ahead, counselor. Vivian opened her briefcase and removed a bound document, 36 pages plus exhibits. She handed copies to the court clerk, to the prosecution, and placed one directly in front of the judge. Your Honor, the defense moves for your recusal from this case, pursuant to Judicial Conduct Code Section 3, on the grounds of documented racial bias in sentencing. The courtroom went quiet. Not the polite quiet of procedure, the deep quiet of shock. Thornton picked up the document. He flipped through the first few pages slowly. His face didn't change, but his left hand, resting on the bench, curled into a fist so tight his knuckles went white. Counselor, he said, his voice perfectly level. I have sat on this bench for 30 years. I have adjudicated thousands of cases, and you are going to stand in my courtroom and accuse me of bias based on... He glanced at the cover page. A statistical analysis prepared by whom, exactly? Vivian didn't flinch. The data was compiled from public sentencing records available through the county clerk's office, Your Honor. It spans a 36-month period and demonstrates a consistent and statistically significant disparity in sentencing outcomes based on the race of the defendant. And who compiled this data? Vivian paused. She didn't look at Darnell. She didn't need to. A concerned citizen, Your Honor. Thornton leaned forward. His eyes moved from Vivian to Darnell and stayed there. A long, slow look. The kind meant to intimidate. The kind that had worked on every defendant who'd ever stood in this room. Darnell met his gaze. He didn't blink. This is a teenager's homework project, Thornton said, tossing the document onto his desk. I'm not going to dignify it with a formal response. That's when District Attorney Nathan Brooks stood up. Mid-50s, white, silver-haired, with the confident posture of a man who'd spent his career on the winning side of every case in this courtroom. He buttoned his jacket as he rose. Your Honor, the state objects to this motion in the strongest possible terms. Judge Thornton is one of the most respected jurists in this county. This motion is frivolous, it's inflammatory, and frankly, it's an attempt by the defense to derail these proceedings and distract from the charges at hand. Brooks turned to the gallery as he spoke, performing for the room the way prosecutors do when they know the judge is already on their side. The defense has presented no expert testimony, no peer-reviewed analysis, and no credible evidence of bias. This is a stunt, Your Honor, nothing more. Thornton nodded, slowly, like a king receiving tribute. The motion for recusal is denied, he said. He picked up his gavel, held it, let the silence stretch. Then he looked directly at Darnell and said, with a voice as cold as marble, "Now, shall we proceed with your case, young man?" Darnell's jaw tightened, but he didn't drop his eyes. He gave a small, deliberate nod to Vivian, just a dip of the chin, barely visible, because this was expected. Every part of it. The denial, the condescension, Brooks's performance, Thornton's arrogance. They had planned for this the way a chess player plans 4 moves ahead, not hoping the opponent will make a mistake, but knowing exactly what he'll do, because he always does the same thing. The courtroom recessed for lunch at 11:45. The gallery emptied. Thornton disappeared into his chambers. Brooks shook hands with the court clerk and walked out smiling. But in the hallway outside, away from the cameras and the marble and the flags, Vivian Cole sat on a wooden bench with her phone in her hand and filed a formal complaint with the State Judicial Conduct Board. Attached, the full statistical analysis, the comparative case file of the white student, the campaign finance records linking Thornton to Ridgeline Corrections, and a USB drive containing 3 audio recordings of a sitting judge making racist statements in his private chambers. Then she made one phone call. Claire Whitfield picked up on the first ring. "It's time," Vivian said. "Run it." She hung up. Darnell sat down next to her on the bench. His hands were steady. His breathing was even. The courtroom was Plan A, Vivian said quietly. Darnell looked at her. The faintest trace of something crossed his face. Not a smile, but the ghost of one. "No," he said. "This was always the plan." Vivian stared at him. 17 years old. She shook her head slowly, the way you do when you're watching something you didn't think was possible. "God help him," she murmured, looking back toward the courtroom doors. "He has no idea what's coming." Something changed in Thornton's courtroom after lunch. You could feel it. The air got heavier, the silences got longer, and the judge was sitting differently, stiffer, his fingers drumming the bench in a rhythm no one had ever seen before. Someone had tipped him off. It didn't matter how. What mattered was this. Gerald Thornton knew a formal complaint had been filed, and he responded the only way he knew how. He hit harder. Court resumed at 1:30. Thornton called Darnell's case back. Vivian stood to begin the defense's opening. He cut her off. "Before we continue, it has come to my attention that the defendant may represent a flight risk. The court is revoking bail, effective immediately. The defendant will be remanded to juvenile custody." Vivian was on her feet. "Your Honor, my client is 17 with no prior record and lives 3 miles from this courthouse. There is no basis—" "I wasn't finished, Counselor." The gavel came down. Deputy Harmon was already walking toward Darnell with the handcuffs. Again. Same deputy, same walk. Darnell stood. He didn't run. He straightened his suit and held out his wrists. But Lorraine was done being silent. She rose from the second row like something held down too long. Not screaming. Clear. "You will not touch my grandson!" "Ma'am, sit down, or you will be held in contempt." "Then hold me in contempt! Hold me in contempt for defending a child!" The courtroom held its breath. In the fourth row, a woman no one noticed held her phone low in her lap, recording everything. Harmon cuffed Darnell. The click echoed. Darnell turned to his grandmother one last time. "It's okay, Grandma. Be ready." The side door closed behind him. That night, Darnell lay on a thin mattress in the county juvenile detention facility, the one operated by Ridgeline Corrections, the company whose money sat in Thornton's campaign account. He didn't have his notebook. He had nothing but his thoughts and the hum of the ventilation pushing stale air through a room that was never meant for someone like him. For a while, he doubted. Maybe the system was too big. Maybe he was just a kid with a dollar store notebook and a borrowed suit. Maybe courage wasn't enough. Then he heard Lorraine's voice, not in the room, in his memory. "You just be ready when your moment comes." He whispered it back to the ceiling. He didn't sleep, but he stopped shaking. What Darnell didn't know was that 3 miles away, the world was shifting. At 7:18 p.m., Claire Whitfield's article went live. The headline, "Cedarville Judge's Sentencing Record Reveals Racial Disparities. Teen Who Spoke Up, Now Jailed Without Bail." By 8, 400 shares. By 9, the courtroom video hit the internet. 38 seconds of Darnell being cuffed while Lorraine shouted from the gallery. By midnight, 500,000 views. #FreeDarnell. By morning, it was trending nationally. A major civil rights law firm reached out to Vivian. Full pro bono support. Darnell woke up in a cell with no idea the world had heard him. And Thornton woke up in his 4-bedroom house with no idea that the walls of his courtroom were about to come crashing down. The hearing room on the 4th floor of the state capitol looked nothing like Thornton's courtroom. No dark wood, no marble, no portraits, just a long table, gray carpet, and 5 chairs behind a raised platform where the State Judicial Conduct Board sat with water glasses and legal pads. Commissioner Eleanor Davis sat in the center. Early 60s, black, silver streaked hair pulled back tight. She'd served on the board for 14 years. She'd reviewed hundreds of complaints. Most went nowhere. This one was different. She'd known it the moment she opened the file. The room was packed. Reporters lined the back wall. Attorneys from the national law firm sat behind Vivian. District Attorney Nathan Brooks sat on the other side, sweating through his collar for the first time in his career. And in the front row, Lorraine Scott sat with her back straight as iron. At 9 o'clock, the side door opened. Darnell walked in. Same suit, same folder. He'd been released 2 hours earlier, after the board's emergency order halted all proceedings in Fortin's court. His eyes were tired, but his hands were steady. A few seats behind the prosecution table sat Judge Gerald Thornton. No bench, no gavel, no robe. Just a gray suit and a face carved from wax. For the first time in 30 years, he was not the most powerful person in the room. Commissioner Davis called the hearing to order. We will begin with the complainant's evidence. Ms. Cole, call your first witness. The defense calls Darnell Scott. Darnell walked to the witness stand, opened the manila folder, and for the next 20 minutes, he did something no one in that room was prepared for. He started with the data. 18 months of sentencing records pulled from public files at the Cedarville Library, categorized by charge, race, prior record, and outcome. Over 36 months, Darnell said, his voice even. 84% of black defendants in Judge Thornton's courtroom received the maximum sentence. For white defendants facing identical charges, 22%. He let the numbers hang. Then the side-by-side comparison. Same school, same grade, same charge, same month. One boy went home. One was handcuffed in front of his grandmother. The only difference between us was the color of our skin. A collective exhale moved through the gallery. The sound of people hearing out loud what they'd always felt but never had numbers to prove. Then he closed the notebook and said the line that would end up in every headline for the next 2 weeks. Your Honor, Commissioner, I'm not asking you to believe me because of how I was treated. I'm asking you to look at the numbers. Numbers don't have a color. Commissioner Davis removed her glasses. She nodded once. Not in agreement, in acknowledgement that what she was hearing was not a teenager's homework project. Then Vivian submitted the audio recordings. 3 files. Authenticated by forensic specialists, corroborated by former court clerk Patricia Bowman. The first recording. Thornton laughing about black defendants. Words no robe could walk back. The second. Names mentioned. Sentences discussed before hearings took place. The third, about Darnell. That boy needs to learn what happens when one of them talks back in my court. I'll make sure of it. The room went silent, the kind of silence that has weight. Commissioner Davis looked at Thornton. Judge Thornton, you will have your opportunity to respond. But right now, this board is going to listen. Thornton's attorney objected to the recordings. Overruled. Argued they were obtained without consent. Davis cited the state's one-party consent law. Every door was already locked. Then Thornton stood. He buttoned his jacket, walked to the podium with the same unhurried stride he'd used for 3 decades. He started strong. 30 years of service, awards, commendations, the burden of the bench. But the words sounded hollow, rehearsed too many times in front of a mirror. When he reached the recordings, he stumbled, called them out of context, called Bowman disgruntled, called the data manipulated by activists. Then he pointed at Darnell. This is a troubled youth, a juvenile defendant manipulated by outside forces to attack Judge Thornton. Commissioner Davis's voice cut like a scalpel. You are addressing the evidence, not the character of a 17-year-old witness. Thornton stopped. His hand was still raised. He looked at Darnell, and for the first time in 30 years, he saw him. Not a case number, not a nuisance. A boy who had walked into the machine alone and taken it apart from the inside. His hand dropped. His shoulders fell. "I have nothing further," he said, and the room exhaled. Commissioner Eleanor Davis removed her glasses, set them on the table, and folded her hands. She looked at the other 4 members of the board. Each one nodded. Then she leaned into the microphone. "This board has reviewed the evidence presented today. Based on the weight and consistency of this evidence, Judge Gerald Thornton is suspended from all judicial duties effective immediately, pending a full, formal investigation. All pending cases will be reassigned. This board is recommending a comprehensive review of all cases adjudicated by Judge Thornton over the past 5 years." She turned a page. The paper sounded like thunder in the silence. "Additionally, all charges against Darnell A. Scott are referred to the reassignment panel with a recommendation for immediate dismissal, given the documented evidence of judicial bias and predetermination." She set down her pen. She looked directly at Darnell. "Mr. Scott, this board owes you its gratitude. What you did, the research, the documentation, the courage to bring it forward while your own freedom was at stake, is not something most adults would attempt." She paused. "You did what this system should have done a long time ago." Darnell's chin dipped. Just once. A small nod that held everything he couldn't say out loud. His lips pressed together. Something behind his eyes released, like a rope pulled too tight for too long, that finally lets go. In the front row, Lorraine Scott lowered her head. Her shoulders shook. The tears she had held through handcuffs and holding cells came down her face in quiet, steady streams. On the courthouse steps, the sun had broken through. Darnell walked out into the light and stopped, blinking, adjusting. He'd been in courtrooms and cells for so long, the warmth almost hurt. Lorraine came through the door behind him. She didn't call his name. She just walked up and wrapped her arms around him and held on. Cameras clicked. People watched. But in the center of it all, it was just a grandmother and her grandson, standing in the sun, holding each other like the world had tried to pull them apart and failed. She put her hands on his face, both hands, palms against his cheeks. "I always knew," she said. "Baby, I always knew you'd be ready." In the weeks that followed, the dominoes fell. Thornton was permanently removed from the bench. Criminal charges, obstruction and civil rights violations, were referred to the Attorney General. Over 200 cases were flagged for review, dozens of convictions overturned, records expunged. The young mother sentenced to 60 days for stealing diapers had her conviction vacated. On the day she walked out of the courthouse, she found Darnell at the bottom of the steps. She didn't know him, but she knew. She hugged him without a word, then walked away holding her daughter's hand. Calvin Moore's charges were dropped. He called Darnell that night. "Bro," his voice cracked. He laughed to cover it. "You really did that." "We did that," Darnell said. Ridgeline Corrections' contract with the county was terminated. The pipeline was shut down. And on a quiet Tuesday evening, Darnell pulled a letter from the mailbox. White envelope, State University seal. He opened it under the streetlight with the freight train rumbling in the distance. Full acceptance, full scholarship, pre-law summer program. He walked inside. Lorraine was at the counter in her work uniform, eating cornbread and drinking black coffee before her night shift. He put the letter in front of her. She read it, set down her coffee, pressed her hand flat on the paper like she was making sure it was real. "Vivian called today," Darnell said, leaning against the doorway. "Asked if I ever thought about law school. For real." Lorraine looked up. "What did you say?" Darnell looked at the letter, at the kitchen, at the woman who raised him with nothing but cornbread, black coffee, and a spine made of iron. I told her I've been thinking about it since I was 12. The Cedarville Public Library closed at 9 on weeknights. By 8:30, the place was usually empty. But on this Thursday, the scratched wooden table under the flickering lamp in the back corner was full. Darnell sat at the head of it, the same seat he'd occupied alone for years. Only now, 3 kids from the east side sat around him. One had a notebook open, another highlighted a court transcript. The third was reading a pocket-sized Constitution that Darnell had bought her for $3 at the used bookstore on 5th Street. He didn't call it a class. He just told a few kids in the neighborhood that if they wanted to learn how the law really worked, they could come to the library on Thursdays. The most powerful thing you can do, he told them, is know your rights. Once you know them, really know them, nobody can take that from you. Not a badge, not a robe, nobody. A 13-year-old boy looked up. But what if they don't listen? Darnell thought about the handcuffs, the holding cell, the gavel. Then you write it down. Every word, every name, every date. And you keep going until someone does listen. Because someone always does. The boy picked up his pen and started writing. Outside, a freight train rumbled through town. But tonight, it didn't sound like loneliness. It sounded like the world moving. If this story moved you, share it with someone who needs to hear it tonight. Hit that like button, subscribe so you never miss a story like this, and leave a comment. Tell me about a time you were underestimated and proved them wrong. I read every single one. Because the truth doesn't need power. It just needs a voice. And yours counts.
What photo, what moral suit, and 30 years of unchecked power gone. He was 17, and nobody saw him coming. Everyone told Daniel to stay quiet. Take the peace, move on, because fighting a judge like Taunton, that's a war nobody wins. But Daniel understood something most people don't. Silence isn't safety. Silence is permission. So while a mother got 60 days for stealing diapers, he sat in the back row and counted every name, every sentence. 18 months alone, 200 cases reviewed, dozens of convictions overturned, a private prison pipeline shut down. That mother got free, holding her daughter's hand. Not because someone powerful showed up, because a boy with a library card decided the truth was worth more than his own freedom. And his grandmother said it back. Don't let this word make you small. He didn't. But he was stay with me. How many truths are sitting in the back row right now, waiting for someone brave enough to write them down? And what if that someone is you? Tell me in the comments, when did you speak up when the world told you not to? Share this with someone who needs it. Hit subscribe, because the truth doesn't need power, it needs a voice.